Great. All right. Good afternoon, everyone. If you're joining us from the East Coast, that is. Good morning if you're joining elsewhere. My name is Shawn Leitner, product consultant and coach for Pathfinder product. I'm joining you here today from sunny tropical Cleveland, cap for those what the kids say nowadays. Typical spring weather here in Ohio. But thanks for joining everybody for today's Ohio X product roundtable. I run the product roundtable series for Ohio X. We talk about all things product management and related topics to innovation, technology, and product here in Ohio. This affords me the opportunity to learn more about product management, innovation, technology from lots of smart people from around our fine state, and that includes Kendra, Shannon, and Paul. So let's go ahead and get started. Today, we're here to discuss intellectual property in product development. I've been a product person for about 15 years. Me and my fellow product people love to create products that our customers love and our teams love building. But we want to make sure we protect our products and our ideas from competition, which that can be kind of intimidating. So we have 3 panels today are here to help us make sense of it all. But before we dive in too deep, let's start with some introductions. So Shannon, can you kick us off?
You're muted, Shannon.
How's that?
Better.
I apologize. My neighbor apparently is having some home repair work, so there's a speaker going in the background.
Of course.
Shannon McCue. I'm an intellectual property lawyer. I've been practicing for over 20 years. I've had the great fortune to work with a really wide range of clients, from startups, mid-sized businesses, to household names like Lincoln Electric, North Face, and AT&T. I'm also on the Ohio IP Alliance board, and one of our goals is education. And I really appreciate Shawn having me here to talk about IP issues, and really excited about the work that Ohio X is doing. Look forward to talking to you about product development and IP. Thanks.
Would you like me to go next, Shawn?
Sounds good.
So Kendra Gardiner, I'm the Director of Product Strategy at UH Ventures. We're a small team of, I think, about 18 now that sits inside of university hospitals. And for those of you that are unfamiliar with the expansiveness of UH, we're about a 32,000-ish employer in Northeast Ohio. We have, I believe, 21 hospitals, many physician offices. I mean, it's a pretty expansive network. But as the ventures team within the hospital, we are the technology commercialization office. And at the crux of that resides a lot of considerations relative to IP. We also work with external companies that are seeking a hospital partner to really access our living lab to further their product development efforts, or pilot or test out what it is that they have developed. But we do that with an eye to partnering to solve the strategic problems of the hospital system, but also with the intention of hopefully investing in those companies. And as a venture investor, we are looking at IP and that portfolio of those startup companies as well. My background prior to UH Ventures was economic development and venture capital in Northeast Ohio through an organization called Jumpstart. But I do see a couple of my former colleagues from my manufacturing life on here as well. And so I have also worked on product development in large corporations, Poly One Corporation, now Avient, over here in Avon Lake, Ohio, which is where I'm sitting today, enjoying the Cleveland weather. And so I had the real benefit of joining a corporation early in my career, which was really kind of trying to transition from being R&D led to market led. And so the considerations of IP, of when do you develop and what's your strategy, was also kind of held in tension as you try to figure out how to take a company from being market led to just generally IP led. So I'll hand it over to Paul.
Very good. Thank you very much, Shawn, and my other panelists, and to Ohio X for inviting me to be able to engage this really fascinating conversation today. And as the slide says, I'm the executive director at the Center for Innovation and Strategies at The Ohio State University, which is where I sit now. And some of you may be familiar with us. We have a stellar women's basketball team that'll be playing for a berth in the Final Four tonight. So I hope you'll cheer us all on. And I have a unique position because I came to the university 10 years ago and worked in our tech commercialization office as well, and evolved through the university to now working with that through our innovation strategy. And of course, intellectual property is a critical component of that conversation and the conversations that we have around our facilitated activities for our Center for Innovation Strategies. Actually, by education, I'm a product designer. I have 26 patents currently, so it gives me a sort of interesting position also, and that I've gone through this process personally a number of times, and hope that my unique perspective may bring something to the table today. So thank you again for having me.
Sounds good. Thanks, everybody. So let's dive into it. Like, what exactly is intellectual property? It's lots of things, right? It's patents, it's trademarks, it's brands, it's copyrights, infringement. Some are on the front end, some are on the back end. Trade secrets, licensing. For those of us that create products, I consult for teams that create products. I've created products in the past. Panelists have created products. I'm sure lots of people in the audience create products, both physical and digital. We want to make sure we create the products that our customers love, our teams love building. These products may be digital or physical, obviously, but we want to make sure our products and our ideas are protected. And again, it can be very intimidating, which drove us to host this roundtable day. As Shannon said, someone in education aspect to his work on the Ohio IP Alliance. So luckily, we could talk about that today. So let's just start kind of 101, if you will. What are the different types of intellectual property? Demystify this for the audience. Shannon, maybe you can kick us off.
Yeah, happy to. Kind of the top three there are what I would refer to as outwardly facing IP, meaning that these are rights that you get by registering them with the government. And we've kind of gone into what's the key consideration for each and how long they last, because they all have some limited protection, except for trademarks. As long as you keep using your trademarks, you can keep renewing it. But patents and copyrights, there's always this trade-off that what we're trying to do is, increase the knowledge base for everybody, that you're providing a disclosure of, a new and useful invention on the patent side, or your original work on the copyright side. And in exchange for that, the government gives you some exclusive rights that we can talk about more later. And then the flip side of that is kind of the inwardly facing IP, which is trade secrets. These are things that have value because they're not known, that they're kind of, within your organization and creates a competitive advantage, or maybe it's the secret sauce, but the rights that you have are based on keeping that information confidential. And so the things that are available, if the cat gets out of the bag and someone steals your trade secret or misappropriates it, there are some remedies through the courts.
Now, Paul, you said you have 26 patents. So, kind of give us some of your experience with that. Like, what was the timeline? Like, what drove you to that? Were they physical, digital? Kind of give us some examples there, if you will, if you don't mind.
No, thanks. No, and I think this is really a great slide to set a baseline, because I think too oftentimes people consider patents to be the only intellectual property. And I think that's really important to understand. There's various ways to protect your work. And, we have a lot of conversations with students in my entrepreneurship classes about the value of patents. And I think too oftentimes people believe that, well, if you go through the process of patenting your idea, then you're sort of in for the long haul, which is policing it and then protecting it and going to fight in court. And in fact, I think that maybe the most, at least for me, and the reason why we really created a patent portfolio that I have was to prove ownership. Because then as a small manufacturing company we were before I came to Ohio State, that was really one of our primary assets, was this portfolio of patents that we owned. It could prove, in fact, through the U.S. Patent and Trademark Office that they were legal entities and assets of our company. And so I think this is another way to look at this protection, is not just in the form of, oh, I'm going to go fight this in court. In fact, you'd hope never to have to do that, right? But the most important thing is it just proves that you've put in the work and that you have that ownership. But I also think it's an important component to recognize that patents shouldn't just be something that you collect, right? Patents should be something that you're actively working on and developing and looking for a way to get them out into the world, as opposed to just putting them aside, which I think is happening too often.
Very good. And Kendra, you're in the healthcare space. Like, which of these do you use when, right? There's different factors for each of these, like Shannon said. But yeah, kind of what are the considerations, if you will, at a high level? When do you use copyrights? When do you use trademarks? What does a trade secret look like?
I feel like most often what I've seen in the year and a half that I've been in the organization and partnering more closely with our inside out team, that really is the one that's kind of culling these innovations from across the organization to bring these innovations forward, is always starting with the provisional application, right? Getting that stake in the ground that there is ownership, which allows us to then go out and start to solicit interest from those vendors or other outside, research organizations that may need to assist us along the way. But as Paul mentioned, just making sure that we have the information filed so that we are protected in those conversations. We don't do that for everything, though. We see, and I know my colleagues on here today, I think we see about 90 invention disclosures a year, and we certainly don't do that for all 90. Not everything warrants or even it qualifies for something that you'd want to take to someone like Shannon, who's going to work with you to understand whether or not you should patent it. So there's a lot of work on just what's already out there before we take anything forward. But then as we get increasingly comfortable with the technology, by de-risking it even further, we will further our commitment, our resources, because it's expensive. We'll talk later about budget. But these things do cost money. And so you've got to be really wise about how you spend that money. I don't know that we've spent as much time on trademarking. We've only, at least in the last 10 years, I think, had 4 companies that have kind of spun out of our organization. A lot more often we're seeing things that we're licensing out. But to Paul's point, if we don't have a stake in ground around ownership, someone's not going to pay us for what is technically something that we own. So that is a real strategy for us in terms of having the patents filed and getting that information in as soon as we can. And in the hospital space, it's pretty tricky because you've got to stay on top of it, because people want to go do a poster presentation. And I know we'll talk about that later. So getting ahead of the poster presentations or submitting for NIH grants or whatever it might be is part of the art that we are kind of faced with in the environment where people are doing research, which turns into innovation. But in this bucket, I feel like we're really kind of more in the patent space, and perhaps seeing our way more over into copyright, as more and more of what we're looking at is around software development, algorithm development, things like that, where that's more in the copyright space. Great.
Awesome. Yeah, great table stakes from an education perspective here. So let's kind of move into, now that we know what IP is at a high level, how do we protect our products and our ideas? Lots of questions to ask. How do we identify what we should cover, what we should not cover? Sometimes that's the more important question to ask. How much does it cost? We kind of hit on a few of these things already. How do we determine how different, how innovative, or how disruptive our product might be in the market, or even compared to our competitors? So kind of what does a intellectual property strategy look like? Like, what's the, how do we go about this? Kendra, obviously we talked about you're in the healthcare space, but you have experience in other domains as well. Kind of where do we start, particularly in spaces that are kind of highly competitive or, fast moving, where do we start?
I think it starts with understanding what you're working on. And what I mean by that is, do you have enough information to know if what you're developing is going to be something that you can eventually turn into a company, like really a company in which you could develop a platform of technologies, or if you're working on a technology that ultimately probably behooves you to think about licensing that out. Because that can really kind of inform how you want to spend your money at the forefront in terms of how far you might actually be able to take that technology or that company at the outset of thinking about it. But I think this is where I've seen, at least in my experience over the years, just sitting down to like work with someone like Shannon to think about, what is my strategy? How far do I plan to take it? How much money do I have? Or how much money do I think I can raise to get me to the runway of X, Y, or Z? I think is a really important consideration. And I think the earlier you can partner with somebody in the legal space to be a partner with you on that, as well as your technology development team, because they can also kind of advise you on what do those milestones look like and what things do we need to work on to de-risk our understanding of this technology and understand the competitive space around us. But I'll hand it over to Shannon. I feel like this is kind of in your wheelhouse, Shannon, where you probably spend, I don't know, probably 100% of your time.
True. Yeah. I think for me, I look at the business goals and then work backwards. And, Kendra and Paul raised great points when we were talking about the previous slide, that there's not really a one size fits all with a lot of these protections. And so sometimes we're layering different things. It might be that we keep something secret, we use copyright and patent in combination, or whatever the budget allows. I can think of we're going to talk about software as an example later. But I had one client who, the budget really just didn't make sense for the expense of patenting and kind of the difficulty in the software space to get patents. And so copyright became, the sole form of IP for that particular product. And, I think the other things that we looked at, are revenue streams. Kendra mentioned licensing. Is it a pure product play? Are we just, making our profit on what we sell? Then we look at how likely is it that we're going to be copied by somebody else? Is it important to protect market share and carve out space with patents that may even go beyond what we're trying to protect on the product itself? So it really varies for each situation, but yeah, usually the goals are, how do we sync up our IP strategy with the business case?
And Shannon, for your, because you're involved with the Ohio IP Alliance, how does, for example, say a small company doesn't have, in-house counsel, for example, how do they engage with somebody like yourself or the Ohio IP Alliance? Kind of talk us through that process a little bit and the partnership that you can build together.
Like I said, the Alliance is relatively new, but it's a great group because it's not just attorneys, right? It's all kinds of IP professionals. And so it's a good resource. If you want to connect on LinkedIn, you can message the board members. We put out informative blog posts and do more webinars like these where you can get kind of general information. And then I think if you reach out to board members like myself, we can provide referrals or give you kind of the heads up, hey, you need to be talking to someone who does licensing, or you really need to be talking to an IP attorney right now, those kinds of things. So yeah, we're intended to be a resource, and so the more the merrier. Please connect, and we can help out.
Great. Paul, question for you. You mentioned protection of intellectual property, but you can't protect everything. How do you determine how can you be selective on the right things to protect, as opposed to spending a bunch of time in Shannon's office, right? Just protecting everything, because that's not sustainable either.
Not that I don't want to, give Shannon a sustainable business. I think that's an awesome, direction to pursue. But one of the things that I know that when we were talking before, this formal discussion today, that we all felt that strategy is such a key word. So I'm just going to mention it like 7 more times, because I do think that whether you are a startup or whether you're a university, you still have to have a strategy. And you know what? I think too oftentimes that word, not just intellectual property, but strategy becomes very, very daunting to people. So I think I want to really also say that my approach has always been very practical, so that when I had, a small manufacturing company, our strategy was just like I had mentioned earlier, our strategy was ownership, because there was just no way I was going to be able to afford, jumping down to the revenue and budget section, I was not going to be able to afford to police and protect. We used to say, if the patent in our case would cost you 1x, then you're going to be at 10x to police it and 100x to take it to court, and you're going to do nothing but lose money, right? And so we always looked at our intellectual property as a way of putting that stake in the ground and then using that as a jump off point for the next product innovation. And so it allowed us to continue to own that stream of innovation as it was protected, and not necessarily worry about the protection side. Now, don't get me wrong, if somebody is really going to stomp all over your patent, you have the right, and in fact, you should be protecting yourself. But again, that just becomes a completely different budget cycle. I don't want to touch on the question where you started, Shawn, which was like, how do you protect everything? So, at a R1 university the size of Ohio State, we're seeing between 400 and 500 invention disclosures, and there's just no possible way to protect everything, nor should we. Kevin Taylor and the group in our tech commercialization office do a great job of triaging those invention disclosures. Some of them are too early. Some of them are not, don't have a protectable element to them. Some of them are protectable purely by, potentially the, provisional application, because it is going to be shown through a grant application, or it's going to be shown through a poster presentation. So I think that you have to keep that a fluid process. You can't just say, okay, this one we're protecting, that one we're not protecting, because not just will the protectability of that technology become important, but the market is going to change. And as the market changes, your strategy should change to depend upon whether you think you have something that's protectable or not. And I think that's a really important process as part of your strategy. And so, again, my point that we had talked about quite a bit earlier is that I'm a huge fan of bringing your legal counsel in as early as you can and let them become part of your development team, because too often times we will bring them in too close to the end and say, here's my beautiful jewel, please protect it. And they say, well, you probably should have come to us a year ago when you were deciding where you were going to go with this and know what our strategy ought to be. So I wish that we could, as the three of us, say, here's exactly the rote process that you should follow. But the reality is that it's going to be different for every company and their overall strategy, not just for IP, but their strategy about their business growth. And then every company is going to look differently at each product coming across the table, whether that, again, product is a physical product or a software product. Each is going to have its unique aspects that need to be examined.
Only want to add one thing here, and I don't know that we had talked about this before today, but I think it's also important to think about your IP, and then as you go out to work with other companies, and how your IP is treated in those relationships too. And I think that that's critical, because some of those legal agreements, unless you actually structure them in a way that says, when we came together, I own my IP, and you came here, you owned yours, and together we may create new things. And how is that treated? And I think that's all, because a lot of times when you're getting going, you don't have the capacity to build out your full bench of whatever you might need to do, whether that's from a technology perspective, a marketing perspective, all the operations functions. And so there's going to be a lot of partnering and vendor utilization. And I can see it from our side as we work with external startups and how we treat our legal agreements in that. But I can imagine on the flip side for people that are on an earlier journey, partnering out, I think that's really critical as well.
Yeah, and I want to follow up on Paul's point about making choices. I think one thing that we haven't mentioned yet is that not everything is protectable. So, some of the decision making is, we're going to do some searching. We're going to find out whether we can even protect this in the first place. Or if we do get protection, how much scope are we going to get? If it's really narrow, then maybe it doesn't justify the cost, And maybe one other thing that would be helpful to give some kind of ballpark of the cost of each of those outwardly facing IP that we talked about. Copyrights are generally in the hundreds of dollars, unless it's something super exotic. Trademarks are in the thousands, and then patents are in the tens of thousands just to get the rights. And, I think Paul is pretty accurate. Litigation is expensive and it's probably 100x, but, there are occasions where it is a useful tool and, might be a way of generating revenue.
Yeah, that's great. And Paul, just to kind of +1 on your conversation about strategy, right? I'm a product consultant. I've been doing product management for a long time. In many organizations, you don't have a clear strategy, whether it's a product strategy of the thing you're building, physical or digital, or organization and business strategy, or maybe you might have one or the other, or you might have both and they're not connected. So, having that to make sure you're building the right thing and then involving the proper stakeholders. We've seen it many times on product. We start to go build the stuff, but we don't bring in our marketing partners or our user experience designers or operations teams. Legal counsel is part of that equation too, from a trademark, from an intellectual property perspective. So definitely seen that, and very valuable to have this kind of conversation, Ohio IP Alliance as part of it, or even your own in-house counsel.
I want to touch on in advance also something that Kendra touched on that's really, really critical, probably in your organization, Kendra, and certainly at the university, is predicting what intellectual property may come out of an interinstitutional agreement, because understanding who owns that background IP to generate foreground IP and who owns what coming into a conversation can oftentimes be a showstopper for a lot of universities. And so what I'm here to say is I encourage you just to have that discussion early. You may say, we're going to create a research service agreement, and we don't really think there's going to be any intellectual property. Well, you know what? You still should talk about it, and you should push to have a provision within that document that talks about who owns what, because I hate to see people lose something that they've put their time and potentially resources into because they are worried about what their rights were, or they're going to worry about how that's going to perceived as a partnership. And I think we're going to touch on this again, but the concept that partnerships should be able to talk openly about what their concerns might be with regard to that background foreground IP conversation. And anytime you're getting into a joint agreement with two separate entities, that has to be part of that legal agreement.
Yeah, and a little plug for UH. We do have a growing portfolio of technology for anybody that may want to evaluate to license out. We've got our invention, our affiliation between Case and us pretty well. Most of the time lined up pretty well. So it's ready to go. So let us know if you want to talk.
Great. Yeah, that all sounds great. And I think we've kind of hit on a little bit of, timing is an important aspect here too. We talked about bringing in, having a strategy, but bringing in, legal representation to, at least kick the tires on IP of what should be covered, what shouldn't be covered, at least discuss it. So, how does timing play here, particularly like things like when you're creating a new product, you're a startup, you're floating the idea around to potential partners or licensees, heck, family and friends and former colleagues, things like that. Things like non-disclosure agreements, the timing for all these different types of IP. What are major considerations here?
Yeah, I'll jump in. I think if we go back to the slide that had the brain that's keeping you up at night, this is the one that gives IP attorneys the most concern, right? that public disclosures have consequences. It can involve losing rights. You look at the patent example we've got up here. If it's on sale or in the public for more than a year in the US, you can't get a patent on it. And foreign countries, are even more strict. Some of them, as soon as it's out, you're done. Copyright, there's some advantages to getting things in early. So touching on non-disclosure agreements, we use that as a layer of protection to avoid public disclosure. If we're trying to work with vendors, or it's a joint effort, let's say, between different entities, we want to have some kind of non-disclosure agreement that ensures that that communication isn't considered a public disclosure. I don't know, Paul, you have anything to add on that?
I think that this is the scariest of all slides, right? I think not just because of the Shannon's position, but it should be also scary from the standpoint of that old adage, loose lips sink ships, right? I think this is something that we talk about a lot, particularly in a university setting or with a student setting, is that and in a world where social media and LinkedIn are just asking for you to disclose what you're working on, right? Everybody wants to have a better resume. Everybody wants to crow about their achievement on LinkedIn or on another social platform. And you just have to be really, really cautious of what that public disclosure looks like. And so, we'll talk to students about this, and they're saying, well, but I just told my parents. Like, well, guess what? That's a disclosure. I just put it on, I just tweeted about the work I was doing. Now, it's always a question of just what you're actually saying, as to whether it's a public disclosure or not. But I think that the one point that I really want to drive home is these non-disclosure agreements or confidentiality agreements. That I love it when the first time I have a conversation, particularly with an external entity, an external startup that wants to talk about a project or talk about a product that they're working on, and the first thing they ask me is sign a non-disclosure. And I think they do that often a little bit sheepishly, as I mentioned with the last slide, that they're worried about, well, what is my partnership position? And my position is, no, good for you. You need to be straight up and stand up for the right that you want to be a partner with them, and you want to be able to disclose without some limitations. And so get that non-disclosure put in place. And I'm sure that Shannon's group does this. They're not difficult to find. I don't want to say you can't go online. The online ones do work, but they're not going to be specific to what you have. So I would always suggest using a legal counsel to help you with that non-disclosure, and ask people for that. I think that's a great show of respect. In fact, one of the most important things, and then I'll hand this back off, is that when we work on projects with students, is that too often times they've never heard of a confidentiality agreement. So when we work with external sponsors of a program we have called OnRep, we're working with the sponsors a concept. We have all those students sign a non-disclosure for them, and we explain to them this can be both a powerful tool, as well as when they go out to interview, I want them to be able to say, I can't tell you about the project that we worked on with this company XYZ because I'm not at liberty due to my confidentiality agreement. That to me says volumes about a student's understanding of the process, and will get them further in that process than it will be if they just start opening up and talking about all the work they did. Not only that, but then I'll fire them. So that doesn't work out very well. But I really like that idea of pushing the confidence that a non-disclosure agreement allows you to have, whether it's with a partner or with a sponsor or with a manufacturing company.
I don't know that I have a whole lot more to add. I mean, non-disclosures are kind of a common practice for us, especially as a technology commercialization office for an academic research institution. And we invite them in as startups come to talk to us too. We know and we appreciate that some of the things that they're working on are not yet market ready. And And so I think, again, that gives us great confidence that we're partnering with somebody who's been really thoughtful about how they've built their company, when we're approached in that way. I was just thinking that we recently have been working a lot and exploring things with NASA. And it was interesting. Our team is really good about questioning whether or not we're at the point of readiness to share. And even if we have an NDA, we always think about, well, how much do I share to be able to move the conversation to a meaningful point? And so I think there's also this, and by the way, if you're ever working with NASA as a federal company, we had to receive their employment contract because they can't sign NDAs. There are some organizations that work for that are working on behalf of the federal government that may be prohibited from doing that, but don't be afraid to ask for their employment contract and have your legal counsel also look at the details of what they're beholden to in terms of receiving information from you as a citizen, or a company, or whatever the case might be. So that's one point, but the other one is think about how much you really need to share to move that relationship forward. You don't have to give it all away. I know it's exciting. It's so fun to talk about what you've made. You want everybody to know how pretty your baby is, but at the end of the day, they might only need to see the little toes and fingers, take the little socks off. And then as you get more comfortable with that relationship, you can share more as is appropriate. And I think that we found that to be a really good practice inside of our organization. And a lot of this, and Shannon, we haven't talked about this, is trust. Trust is everything in every relationship, no matter what agreements you have in place, whatever NDAs you have in place. You've really got to suss out the trust between yourself and the organization you're working with, because these legal agreements and everything can go a long way, but trust is really kind of paramount.
Yeah, I agree. I mean, those are great points. And I'm thinking of like the government contracts, funding, like if you're getting grants and things like that, you got to look at the fine print. Because, getting beyond the NDA issue, you may be dealing with ownership, right? That I know like NIH is a good example where if you're getting funded by NIH, then the government is automatically getting a license, right? And like you said, they have requirements about what kinds of agreements they can enter into because they're a government.
Mm-hmm.
And yeah, the final point is a great one, that Paul mentioned, litigation's expensive. We don't really want to go there. I mean, these agreements are there for when things go wrong, but ultimately you can, determine, the trust relationship and try to start off with a good foundation that hopefully prevents those things from happening.
That's all good points. Kendra, I think you had mentioned, I lost my thought. It was about, it really comes back to storytelling, right? What's your product? What's your idea? What's your solution? And a lot of us on the product side, in particular on the digital side, get all excited about the technology, right? About we're doing artificial intelligence or machine learning, right? And even where it's hosted on cloud services or whatever, and we lose somewhat of focus on either the strategy or what problem we're actually solving, right? And that's where the value comes in, right? Because the technology can change over time. You can find different partners that you can work with to push your product out to market or license it or whatever. But it's all about the storytelling to hook your potential partners or VC or whatever, to be able this is the problem we're solving. This is value we bring to the market. And then, the technology can be a secondary or a tertiary conversation, and appropriate with the appropriate parties at the right time. Kind of good segue into the next topic about, okay, a lot of us here, a lot of the audience is technology, innovation, software, digital related. So let's kind of run through kind of a case study. We talked a little bit about table stakes of IP, kind of what it is, defined it, things to watch out for, considerations. But what, kind of let's talk through software and which is going to be a kind of unique space in terms of what do you do? Do you trademark it? Do you patent it? And kind of let's talk through maybe, Paul, maybe I'll toss to you first. what are major considerations when you talk about software and digital technology solutions in IP?
Well, I don't think that regardless of this wording now has become a little bit interchangeable about the term product, whether product refers to a physical product that may have been a traditional interpretation of that, and now product refers also to digital product as well, particularly when it's related to apps or to algorithm-based functional programming. And it's really it's much more difficult subject to jump into because everybody's out there like Jim Carrey just pounding out this code. And worse yet is that there's some of that code that's going to be original. There's some of that code that's open source. That's some of that code that's being shared across unprotected platforms. So it becomes very tricky. And I think that we've also discussed in earlier conversations that a more traditional patent process is really difficult with software product. But copywriting is a way that you can protect that specific code, but knowing where to start and stop that code becomes a bit of a challenge even from a copywriting standpoint. And then you come to a discussion around trade secret of just not exposing your code. But I think the most important case study to be cautious of is that so many startups or small companies that may not have a dedicated digital team are going to an outside consultant to have that code developed, and oftentimes going offshore to have that code developed. And one of the biggest challenges that we've seen related to the protection of a digital product is lack of ownership, that unless you have contractually declared that you as the paying entity for that software that's being developed in Pakistan, that then you don't own it. And when it comes to and I'd love to hear Kendra's perspective on this too. When it comes to having a conversation with VC about investing in your company, and they say, well, it's great, you've created a wonderful app that does these very unique things. So show us the contract language that shows that you as a small startup actually own this. And that's a stall point for a lot of small companies. So my case study is don't neglect the protection of your software. It's just going to be a slightly different path you're going to have to go through in order to make sure that you clearly own it and that you can protect the asset, again, that you've paid for to develop.
You're absolutely right. I can remember when I went through VC university training a couple of years ago, which is really kind of focused on training around venture capital from the lens of the entrepreneur, not the venture capitalist. And so I found that to be one of the most, it's through Berkeley. And they talk so much about this, Paul, where now you're not only thinking about your legal strategy, you're thinking about your hiring strategy. And what does your HR contracting or your vendor contracting look like as you're thinking about these particular, writing code, protecting things? How do you separate your teams? What can they or can't they do when they leave your organization? As it's developed, who owns it? And really, these can be tipping points in terms of being able to unlock equity investment from the more of the savvy VCs who are kind of going to comb through all of that in their diligence process. So I think it is absolutely critical. I think what we're seeing in the healthcare space too, as we're now kind of finding our way into technology development and biomarkers, where there is this growing, can we use biomarkers, whether it's facial recognition, voice, blinking, probably, I don't know, coughing, I don't know what they might be. But a lot of that, you could almost protect yourself. And I'm curious to see where this will go, because a lot of that, you have to kind of be at the leading edge and have a hospital partner to use, actual data to confirm through standards of care versus these biomarkers. So it does give you a leg up in terms of being able to validate your product. But I think the protections of that going forward are going to look very similar to what we see in the software space, because you have to then code that into real code that can kind of sustain it over time. So there might be some additional protections to explore. And again, we're kind of on the precipice right now of just like simply purely writing code to do something, but now you're combining, which is more of kind of an AI play, which is interesting. But I think you hit it out of the park. And I just come back to your legal strategy now meets kind of HR contracting strategy.
Yeah, I'd agree. I think maybe we give Paul like an honorary membership to the bar after that one. Yeah, you nailed it. That, especially copyright and patent, the ownership lies with the inventor or author, unless there's some specific agreement that changes that. And in a company setting, even being an employee doesn't necessarily get you there, right? Unless the employment agreement is very specific about who owns what. And, so usually when we go through these processes, we are doing our own diligence before we even file for any kind of protection, that we want to make sure that we've got these issues kind of cleaned up and in place, before we go spending a bunch of money on, trying to get IP rights. And Kendra is absolutely correct. Like, when someone outside is looking at your company, they're definitely going to come through these issues, to make sure that, what they're investing in or what they're buying into is actually what they think they own, right? So yeah, critical, first step. And I'll throw some additional layers on it. Certain foreign countries have rules about where you file first. I don't know how many people are going to China for software development, but if you're working with a Chinese individual under their law, you have to file in China first, or otherwise that person can actually go to jail. There's lots of strange issues when you get outside of your own country. It's important to think about these things, think it through. I always look at, like, there's two big circles. There's the internal IP ownership, which is like your employees, and that's, your employment agreement, individual contract with employees. And then there's the outside facing things, which could be contractors that you're just bringing in for a particular project, or joint developers, like another partner that's going to help develop the product with you. You really have to have an understanding of who's working on this. Are their agreements good on their side? And then do we have a good agreement on our side to make sure that ownership is clear?
I think there's that Kendra brought up something that, is as timely can be. And that's not just AI, but ChatGPT, right? What happens when true AI begins to create what might have at one point been creative works? Or maybe it's creating code. I mean, what's to say that within, I'm going to say months, not even years, that I can say, oh, I need a code to be able to calculate XYZ, and ChatGPT will give me the code for that. And it might even be custom code, right? So these are, it's funny because I think we could be sort of raising the doomsday flag, but actually I want to be on the other side of it and saying, I think these are all exciting conversations, because it starts talking about this ownership. It starts talking about where is truly, if you think about that word, intellectual property, what is it that you own, and what is it that you developed, and what can you do with that? I think these are exciting conversations, scary, but they're really exciting conversations at that.
Yeah, I think
Yeah,
AI is definitely, it's working its way. I mean, we've kind of been looking at it for years on the IP side, but we're now seeing the cases come through, the copyright office, the patent office, and the courts, and each is kind of speaking out as far as the ownership issue goes. It's not decided yet, but kind of the general sense is that AI can't be an inventor or an author by itself. And so that human interaction with the AI is going to become critical in terms of determining who the author is. And then before we move off the software example, I think, getting back to that layered approach that we talked about, this is where it becomes important, that, we need to figure out what is the most appropriate way to go. Maybe it's more than one way. And then, kind of looking at it in terms of, the budget and where we have our ducks in a row. Like if we got some questions about who owns what from a patent standpoint, but we're clear on copyright, then maybe copyright is the answer. You know, that all these things kind of weigh in. Software is great because, like Paul said, it raises all kinds of interesting issues and there's all kinds of IP available. You know, that you have a written component, which is copyright. You know, there's processes and everything that could come into the patent space. And then you have the public facing things like your UI that are potentially protected by a design patent, which we haven't spent a lot of time on. And then branding, you know, you have your trademark issues. So it really is a nice use case because it touches on everything.
Yeah, that sounds great. Yeah, Paul, you brought up Chat GPT, that was on my mind, right? Generative AI. But then, a recent announcement here in Cleveland, right, with quantum computing in the healthcare space, things are just moving very quickly on the software side. Even low code solutions, maybe not generative AI, but things that can be done with less, fingers on the keyboard in a lot of ways. It's still protectable, still IP, but definitely need to talk through, with your partners, legal partners, internal, external, about what that looks like and what problems you're trying to solve and what's protectable, what's the right protection for it. So good stuff. All right. That's all the conversation we had, all the topics we had for today. Any questions from the audience? Any parting thoughts from the panelists?
Yeah, my parting thought is, I know we really just touched the tip of the iceberg here, but you've got some great resources in, Paul and Kendra, Shawn, OhioX, and certainly additional resources at Ohio IP Alliance. I think our contact information is in the slide in case you have questions that you think of after today. So feel free to reach out. Thanks.
Awesome. Well, I can't thank you, panelists, enough. Kendra, Shannon, Paul, this is awesome. I learned a lot. It's been great to learn from you guys. As Shannon said, feel free to reach out to any of the panelists here. Happy to have conversation about what IP is, where you are, we want to protect. OhioX is an organization that is advocating for technology and innovation within the state of Ohio. So protecting the intellectual property is part of that conversation. So, that's the purpose of these types of roundtables and having panelists that know their stuff, share that with everyone today. So thanks everybody who joined us today. Thanks for those of you that are watching us later on YouTube. Enjoy your day. Thanks everyone.
Thank you.
Take care.